Good afternoon. May it please the court. My name is Krish Purswani. I'm the appellant in this case, and I was the respondent in the two cases in the trial court below. Those two cases related to a petition for an order of protection against me, and which I'm appealing. I think the most important thing in this case is that after the petitioner filed her petitions, she dismissed them. She filed notices of dismissal, and they are in the record. For example, on page 7 of the record, there is a notice of dismissal with voluntary prejudice that she filed in her own handwriting, in which she says she dismisses her petition, and this was before trial. And then on page, this was on September 10, 2017. Which was filed on September 12th, and that's on page 25. Then on page 15 in the record, there is another notice of dismissal that she also filed with prejudice, dismissing her second petition, which she had filed after she dismissed the first. And how that happened, I'm going to get to that in just a minute. But the reason I want to mention that up front is because I think this is the gist of my appeal, and this is the gist this is the most important reason that I'm requesting this appeals court to vacate the order, because the cases had already been dismissed before trial. And then there is a third notice of dismissal on page 16, which was filed on March 9th, 2018. These three notices of dismissal were filed and thereby extinguished the action. And under Rule 41 of the Tennessee Rules of Civil Procedure, a petitioner or a plaintiff can take a voluntary dismissal at any time before trial. And even the case citation that I have supporting the right of a plaintiff to take a voluntary dismissal is Ricketts versus Sexton, which I have mentioned on page 18 of my appellate brief. And if I may take a minute to quote that, because I think this is important. As I state on page 18 of my appellate brief, and Tennessee, I believe it is the Supreme Court, in Ricketts versus Sexton, 533 SW 2D 293. And it says, quote, the rule, that is Rule 41, specifies that a plaintiff court, this is the courts within the court, shall have a right to take a voluntary non-suit or to dismiss an action without prejudice by filing a written notice of dismissal at any time before the trial of a cause. End of quote. This portion of the rule is not dependent on the determination of the trial judge. The lawyer for the plaintiff is the sole judge of the matter, and the trial judge has no control over it. It is not necessary that he approve the action of plaintiff's counsel by signing any order, nor may he nullify the rules by an order disallowing the non-suit. All that is required to dismiss prior to trial in the absence of the existence of any of the exceptions above noted, which, is the filing of a written notice of dismissal. Third paragraph, quote, the plaintiff is the master of the suit and may dismiss at his pleasure before trial. And this is not just supported by case law and the Tennessee Rules of Civil Procedure. It is the basis of civil procedure, that anybody who does not want to file a suit, even if they are injured, nobody can force them to file a suit. This is all over the world in every common law or civil jurisdiction, that if somebody is injured and if they have a claim against somebody else, but they don't want to sue, or even after the suit, they decide they don't want to sue, they can dismiss it. Nobody can force them. So how did we come? How did we end up having a trial in this case? That is interesting too. But to get to that, I want to go back a little bit and give an overview of how all this started. This is basically a dispute over a car. It started off as a dispute over a car, a blue Nissan Maxima. I and the appellee, we've been separated since about 2014 and live in two separate counties. She's in Hawkins County, and I was in Sullivan County for the most part. And the car, as the record shows, it belongs to a company, and she wanted the car for free. and she threatened that if you don't give me the car for free, I'm going to file a restraining order against you. And that was proven by her text messages. On record page 27, there is a whole slew of text messages from her dating to about August 21, 2017. It says, quote, "I will call the police on you for stealing my car. I will bring it back right now." There is a slew of messages at about 8:37 p.m. And then a second set of messages says, "I will call police tomorrow and tell them that you stole my car. Good night. Troubles are coming to you." Then there's a third set of messages which says, "Angelina will not go to school unless you bring the blue car here." And then there is a fourth set of messages. That is the day after she went and filed the petition for the order of protection. This is, I believe, the day off. It says, if you look at page 27 in the last column, the message from the one before the last one, the one prior to the last one, it says, quote, "I am calling to the court right now to file a restraining order against you. You asked for it, now you get it." And then the next day, this is the final message. It says that I filed a restraining order against you because you took my car. Well, so it was very clear that this was all a dispute over financial matters. In fact, this was something that is a pattern for her. For example, if we go back and look at the facts on page 26 in the record, she sent a fax in 2014, a few years prior, where it says very clearly, "Give me $500 or $600 or I will file a restraining order against you." So we have an appealee here who uses this threat of filing petitions of orders of protection to get money out of a victim. So basically what happened after that, after she filed her petition for the order of protection, the parties settled, and I was forced to pay her a $500 instead of the car, which was done by check. That is on record page 28, dated September 10, 2017, a check for $500, which she cashed. And after she got the check, she went ahead and dismissed her petition for order of protection. And at this point, again, there was no trial had been held yet, so she dismissed it before trial. Then a few months later, she wanted more money. So she repeated the whole scam again. She said, "Now give me more money, or I'm going to file one more order of protection against you unless you give me more money." And she wanted cash, so some cash payments were made. And after some time, when the money was not enough, she went and filed a second petition for an order of protection against me. And again, I had to pay her $200 cash, which this time she agreed to accept it in writing and provide a receipt, which is page 29 of the record on appeal, in which she agreed she had received $200 as consideration for dismissing her petition for order of protection. Again, trial had not been held. So how did the trial court end up having a trial and issuing orders? And that's also is pretty interesting. After she had dismissed her cases, after she had dismissed her first case, she started receiving telephone calls from the clerk of the court. And the clerk told her that she needs to come to the court because the judge wanted to see her. The judge that had been assigned to this case was Judge Beth Boniface. That was pretty unprecedented that a judge would ask the clerks to call a petitioner and demand to see her. Well, she did not, apparently she did go sometimes. It's not quite clear how often she went, but what was interesting was when she did not go, the judge had subpoenas issued sua sponte against her. In other words, the judge forced her to come to court to litigate a case that she had already dismissed. And the judge also had the clerks issue subpoenas against me also to force both of us to come into the courthouse and litigate a case that the plaintiff had already dismissed and no longer wanted to prosecute. And those subpoenas are in the record on appeal in the second volume, in the supplemental record on appeal on page 1 and page 2. The reason I had the clerk include the printout of the case activity is to show that neither party went to the court and demanded a subpoena against the other party. Under Rule 45, subpoenas are issued against non-party witnesses, and they have to be requested, and they are filled out by the clerk on the request of a party, which did not happen in this case because nobody requested. By forcing both parties to attend court, Judge Beth Boniface basically pressured and probably put the petitioner in fear, the appealee in fear, that she must prosecute her case. Well, eventually there was a trial of the case. Now, I believe the fact that the cases were dismissed already and she had filed her notices of dismissal would have been enough for the judge to close the file and would not have given the judge authority to conduct the case. And I believe that the fact that these cases were dismissed with these 3 notices of dismissal in the petitioner's own handwriting, I believe is grounds enough for this Court of Appeals to vacate the order of the trial court. Because once a case is dismissed, it's dismissed. The court does not have authority or subject matter jurisdiction to litigate a dispute when there is none. But in any case, if this Court of Appeals does not accept that argument as being enough to vacate the trial court's order on the grounds that they've already been dismissed 3 times by 3 notices of dismissal, then I think we come to the other issues. During the trial, there was no evidence that this petitioner appealee was in any danger. There was no evidence of domestic abuse. The orders of protection are issued under TCA 36-3-600 et sec. And under TCA 36-3-605B, the petitioner has to prove domestic abuse by a preponderance of evidence. And I have detailed in my brief why she failed. In her own, during the trial, she admitted that in her notice of dismissal, she had recited that she was not in any danger. And the reason was simple, because we lived in different counties and we had been separated for years. She was angry because of a loss of driver's license and angry over the car. Apparently they had suspended her driver's license because they found out that she had some mental concerns, but she was angry about that, and she admitted that she had sent those text messages. She admitted that she had threatened to get this order of protection because she wanted the car, and she had no objective evidence of any domestic violence. She could never give any specific facts to show when and where and how any abuse could have happened. Unfortunately, Judge Beth Boniface